Ready, start. Miss Purnima Singh, learned counsel appearing for the appellants, has argued that the recruitment of the group single inverted comma C single inverted comma close non-gazetted posts is governed by the master circular, and in clause 2 of the said circular it is clearly specified that the initial period of training wherever prescribed for the various categories of group single inverted comma C single inverted comma close posts is an important prerequisite to be successfully fulfilled before absorption of a trainee in the post for which he/she has been recruited. Further, Clause 3 specifies that the qualifying examination at the end of the initial training of the directly recruited non-gazetted staff must necessarily be a written test. Clause 3.1 says that the candidates should be warned at the time of their recruitment that their retention in service will be dependent upon them successfully completing the training and passing the requisite test. It was further submitted that the Railways wide RVE number 11/2010 dated 15/1/2010 had published the revised training module for the 52-week training program. The said 52-week training encompassed 8 different modules, and the candidates had to go for each and every module for a specific period/weeks. In the event that a candidate failed to clear the training in any module in the first attempt, he/she could be provided a second attempt without stipend if the candidate belongs to general and OBC categories. In cases of candidates belonging to SC/ST categories, a second attempt can be provided with stipend, and such candidates are also entitled to a third chance to clear the training without stipend. It was further submitted by the learned counsel that in the employment notice as well it had been clarified that the selected candidates will have to undergo training wherever training has been prescribed for the posts, and in the provisional appointment letter issued to the respondent again it was clarified that during the probation period of 2 years, if his performance in the field of training was found unsatisfactory, his services were liable to be terminated. Ms. Singh has argued that from a combined reading of the provisions of the Master Circular, the employment notice, and the provisional appointment letter, it is apparent that after completion of training, every selected candidate is required to undertake an examination to ascertain whether he/she has successfully completed the training or not. The learned counsel has contended that it is not in dispute that the respondent had failed to clear the G and SR training despite being provided 2 chances, and therefore there was no illegality in terminating his services as per the provisions of the Master Circular governing the field. It has further been argued that in the impugned judgment, the High Court has failed to appreciate the said position and erred in allowing the writ petition filed by the respondent. Counsel for the appellants has argued that learned single judge has erred in observing that the appellants have not prescribed any departmental examination for the purpose of giving permanent status against the post of SSE.